Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about conditional sentence breaches. Cases that should have gone to the Supreme Court of Canada, but didn't. Richard Sauvé-La Liberté was given a conditional sentence for 126 days. A conditional sentence is essentially a sentence that would otherwise be served in jail, but to be served in the community on specific conditions. A consequence of breaching your conditional sentence is that the conditional sentence order is terminated, and the remainder of the time left on the sentence is served in a custodial facility, in jail. Mr. Sauvé breached his conditional sentence order and was sentenced to jail as a result of the breach. The time remaining in his conditional sentence order was a sufficient amount of time that the sentence was eligible to be served intermittently. However, the original conditional sentence order was 126 days, which would have made it impossible for him to serve that by way of an intermittent sentence. The court imposed an intermittent sentence even though the original sentence was not 126 days in length. And the Crown appealed, arguing that the sentence was unreasonable because he shouldn't have been allowed to serve it intermittently because of the length of the original sentence that he was supposed to be serving in the community. This case obviously raises an important issue about the intermittent sentence provisions of our criminal justice system and the questions about what happens when somebody breaches a conditional sentence order. The whole point of a conditional sentence order is to give somebody the opportunity to serve their sentence in the community so that there's less impact to their life as a result of the sentence that they're given. For example, they can continue to work and to grocery shop and to look after affairs at their homes. Conditional sentences allow for that. They're essentially a form of privilege that's afforded to individuals who demonstrate that they can abide by it. If people are looking at getting a conditional sentence in a jail sentence that would ordinarily not be eligible to be served intermittently, then isn't there a problem if those individuals then breach? People could just wait to breach their conditional sentences until they're eligible for an intermittent sentence and then get the benefit of both worlds, particularly because in many circumstances, intermittent sentences actually result in less time being served because of the time that's counted from when you report to when you're released, which aren't full days, but credit is given for full days in those circumstances. This potentially has the effect of incentivizing people to breach their conditional sentence orders by making it easy for them to be about in the community and lifting many restrictions that would be on them because they're serving the intermittent sentence as opposed to being bound by a conditional sentence order. That can't be something that our justice system can allow, but at the same time, it isn't fair to restrict the ability of individuals to serve their sentences intermittently if that is available to them in the criminal code. And the Supreme Court of Canada had a huge opportunity here to address these competing interests, the interests of the accused and the reasonable expectations in the process, and the interests of the Crown and the protection of the public, and come up with a happy medium or come up with some explanation of why this is or isn't allowed. This was a case where the Supreme Court of Canada ought to have chimed in to give the public certainty about its safety, to give people who are sentenced for offenses where they receive a conditional sentence certainty about what's going to happen to them if they breach. And unfortunately, in these circumstances, the door is kind of left open. Hopefully it doesn't take another case where people breach their conditional sentences before this issue makes it to the Supreme Court of Canada, but we expect to hear something about it in the future. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.